5 seconds to go. Start. A violation of separation of powers between the principal three organs of the state need not rise to the level of violation under the provisions at issue in Indira Nehru Gandhi versus Raj Narayan AIR 1975 SC 2299 1976 to SCR 347 1975 supplementary SCC 1 Minerva Mills Limited versus Union of India AIR 1980 SC 1789 1983 SCC 625 1980 Karnataka LT 573 L. Chandra Kumar versus Union of India 1997 3 SCC 261 AIR 1997 SC 1125 1997 Lab 1C 1069 IR Coelho versus State of Tamil Nadu AIR 2007 SC 861 2007 AIR SCW 611 2007 to SCC 1 before the Supreme Court will consider it an abrogation of the basic structure. The appeals involve questions relating to the constitutional validity as also the interpretation of sections 2, 3 and 5 of the Prevention of Terrorism Repeal Act 2004. While the relatives of the victims are aggrieved by the rejection of their challenge to sections 2, 5 and 5 of the said act, the POTA accused are aggrieved by the direction to read section 2, 3 subject to section 321 of the Code of Criminal Procedure. To appreciate the rival contentions, the reasons that led to enactment of the Prevention of Terrorism Act 2002 and its repeal required to be noted. The relatives of the victims contended before the Supreme Court that sections 2, 3 and 2, 5 of the repealing act were unconstitutional as they amounted to encroachment of the judicial power of the state. Alternatively, they supported the decision of the High Court and contended that once the special judge took cognizance of the offence, the proceedings could be withdrawn only under section 321 of CRPC. That the review committee, being purely a committee appointed by the executive, had no right to determine the innocence or otherwise of an accused. They expressed an apprehension that if the review committee reached a wrong opinion, there would be no remedy. They pointed out that if section 321 CRPC was applicable, there would at least be a judicial scrutiny before the opinion resulted in withdrawal. The POTA accused contended that once the review committee held that there was no prima facie case to continue the proceedings against the accused, the case should, by virtue of section 2(3) of the repealing act, be deemed to have been withdrawn. The state of Gujarat contended that the High Court had rightly held that section 2(3) of the repealing act did not dispense with the requirement of section 321 CRPC for withdrawal, and that after the review committee formed an opinion, the same would have to be placed before the court by the public prosecutor with an application, and the court would have to independently consider such application and come to a conclusion whether it should consent to the prosecution being withdrawn or not. The Union of India submitted that the power exercised by the Review Committee under Section 2(3) of the Repealing Act, though not subject to the supervising power of Special Court under Section 321 CRPC, was amenable to the power of judicial review of the High Court under Article 226. Thus, there were adequate safeguards against any misuse or abuse of power by the Review Committee under Section 2(3). Article 254 contains mechanism for resolution of conflict between central and state legislations enacted with respect to any matter enumerated in List 3 of Schedule of Constitution. It is attracted only if the conflicting central and state legislations have been enacted on any of the matters enumerated in List 3 and not if enacted with reference to entries in other two lists. The questions which arose for determination in the appeal were whether Section 38C of the Bombay Sales Tax Act 1959 and Section 26B of Kerala General Sales Tax Act 1963 and similar provisions contained in other state legislations by which a first charge was created on the property of the dealer or such other person who was liable to pay sales tax, etc., were inconsistent with the provisions contained in the Recovery of Debts Due to Banks and Financial Institutions Act 1993 for recovery of debt. Stop.